Good afternoon, everyone. Hope all of you are doing great. A very warm welcome to all of you as we commence our 11th session of this India ADR week. I'm Keval, a partner with Mazars India in the forensic accounting and commercial damages practice. Today's session, Effective Advocacy in Arbitration Hearings, is hosted by and presented to us by Fountain Court Chambers, for which we have an excellent panel here today. Let me quickly introduce them to you. Firstly, we have Mr. Andrew Pullen, a member of Fountain Court based in Singapore, before which he practiced as a solicitor advocate in Allen and Overy's International Arbitration Group. Mr. Pullen is an English qualified barrister and specializes in international arbitration, appearing as a counsel and sitting as an arbitrator. Welcome, Mr. Pullen.
Thank you.
Next on, we have Ms. Anneliese Day, a barrister and QC at Fountain Court Chambers, London. Ms. Day expertises in dealing with courts and tribunals as both lead counsel and arbitrator in the UK, in Asia, Middle East, and the Caribbean. She also regularly appears at appellate level. Welcome, Ms. Day.
Thank you.
Next, we have with us Ms. Niamh Cleary. Ms. Cleary is a barrister and a member of Fountain Court Chambers, London. Ms. Cleary has extensive experience of heavy litigation and complex disputes, both domestic and international. She is also on the Attorney General's B panel. Welcome, Ms. Cleary. And last, but of course not the least, we have with us Mr. Nik Yeo. Mr. Yeo is a barrister and a member of Fountain Court Chambers, London. Mr. Yeo is highly experienced in trial and appellate advocate in litigation and arbitration. His diverse practice includes fraud, fintech, and finance. Welcome, Mr. Yeo. Just a small mention on the housekeeping part to the audience here. The session is being transcribed and recorded. Without holding too much further, I now hand over to Ms. Cleary for to take over this session, and we'll see you soon. Thank you so much. Over to you, Ms. Thank you.
Thank you very much. And thank you all for joining us today for this panel discussion on effective advocacy in arbitration. We're going to use a discussion panel format, and I will get the ball rolling with some general questions on the key aspects of arbitration advocacy, but we would also love to have any questions from the audience, which we will try to work in. If you add your questions in the box, we will pick them up as we go along, so far as we're able to. And then we'll also deal with questions at the end if we have time. So the first topic that I wanted to ask the panel about today is knowing your tribunal. So as an advocate, you're often reminded, particularly as a junior advocate, one is often reminded of the importance of knowing your tribunal. Particularly in international arbitration, where you have various participants, parties, lawyers, arbitrators from different cultural and legal backgrounds. But I mean, how do you even start to get to grips with knowing your tribunal in a practical sense? Andy, do you have any advice on this topic?
Yeah, sure, Niamh. I mean, I think this is an important topic and a good one to start with, because it really pervades everything you're doing throughout the arbitration, and knowing your tribunal kicks in as a consideration right from the start. If you're one of the advocates, you're often asked to advise on who to appoint to the tribunal, and so thinking about the sort of arbitrator that you want to appoint or advise your clients to appoint is an important and very important, one of the very important early decisions. And I think how you can do that, to some extent, it's a question of research. You may be able to find out certain things about them through the internet, through consultation with colleagues, through consultation with others that you may know in other firms or other chambers. It can also come from participating in events like this, and obviously in normal times we would actually get together and be able to talk to people, and you would get to know people through that way as well. So there are kind of formal and informal ways of trying to get to know some of your potential arbitrators in advance of a particular arbitration. Once you get into an arbitration, you've got a panel appointed. It's then something you have to think about as the arbitration goes on, and as you're making your submissions, as you can get to the both in writing and as you get to the hearing. And I think one of the key differences, I think, in arbitration compared to a court setting is the fact that if you're in court, you're typically appearing before a judge who has the same legal background as yourself. Often, but not always, you'll be dealing with the law that you're both trained in. And so everything's relatively familiar. Once you get into an international arbitration in particular, that is often not the case. It's very common to have arbitrators qualified in different law to the advocates. They may not be qualified in the applicable law. They may be more or less familiar with the law that's applicable in the case, and the laws that they are trained in may be more or less similar or closely related to the law that you're arguing about and the law that you as an advocate are trained in. And so I think that's something to really think carefully about when you're working out how to approach the case and how to make your submissions. And there are, I mean, there's some obvious points like avoiding shorthand or jargon that you're familiar with and that anyone in your system, your legal system and training would be very familiar with, but others may not be. But there are also more substantive issues as well. So thinking about whether you're going to need to step through the basics of the legal regime that applies than you would do in court. I mean, an example of this would be a contractual case where if you're English barristers like us, if you're appearing before an English judge, we all know what the word repudiation means. We all know what frustration means in the context of a contract, but that may not be immediately obvious to someone from a different background. And so you need to think about whether you need to explain that more. And you also need to think about whether concepts that you may refer to have a different meaning to somebody else. And somebody that's learned a foreign language is often familiar with the idea of a false friend, something that sounds very similar to what you know, but actually means something quite different in the other language. And so an example of this could be, for a common lawyer, estoppel. Most common law systems will have a notion of estoppel. They will have a common root somewhere, but they've developed in different ways in different countries. And so English law doesn't treat estoppel as a cause of action. The Australians and New York law have gone much further in that regard, and so it may mean something different. And so those are things where you need to be quite careful if you're the advocate arguing about that to make sure you've dealt with it clearly and engage with those potential differences.
I guess knowing your tribunal is going to pervade almost everything that we're going to be talking about today. But one thing we might not otherwise touch on is written submissions. And this was a big gear change for me coming from a common law background, how the approach to written submissions is quite different in international arbitration. Obviously, what you do in terms of written openings will depend on whether your arbitration is based on common law style pleadings, where you have to put in a written opening because it's your only opportunity to kind of write persuasively to the tribunal. But obviously the situation is very different where you've already had a chance to make your arguments in a memorial style arbitration. Nik, do you think it is helpful in a memorial style arbitration to file pre-hearing submissions? And are there circumstances where you would consider doing so?
Well, there are certainly pros and cons. In terms of the advantages, it allows you to draw together the key elements of, of your case succinctly. You can cut through what may well have been very, very voluminous memorials, which the tribunal may have difficulty navigating. The tribunal may, for example, be struggling to identify the wood for the tree, as it were. A logically structured, concise skeleton or written opening can really correct that. And it also gives you a chance to refocus your case, if necessary, after all of the memorials, after the disclosure, and all of the factual and expert evidence is in. Also, as a lead advocate, you may not have been closely involved with the presentation of the case up to that point. So it may also give you a chance to refocus the case at that point for the submissions.
To correct all the mistakes your juniors have made as they were going along.
We're allowed to say that as juniors, yes. You can include in these sorts of written submissions things that might be more informal, that you might not want to have put in your memorials, charts, tables, bullet points, summaries. You can obviously accompany them by, and you may be required by the tribunal to accompany them by things like chronologies and other documents, dramatis personae, for example. These are all very useful documents around which you can build your oral submissions. But don't just treat your written submissions as a script for the oral submissions. Do not just read them out. They can certainly be used to cut down the length of what you might need to present orally, which is particularly important if, for example, you're operating under a chess clock. And also written openings should be borne in mind if you have one of these arbitrations, which seems to be increasingly common in my experience, where adjournments are planned in during the course of the arbitration. For example, one arbitration I was involved with, there's a 4-month adjournment during the course of the arbitration. In those circumstances, written openings are very important because they can enable the tribunal then to get back up to speed in a very handy way before the reconvened hearing. But don't lose sight of the downsides of written openings. They do obviously add to the pile of paper, and then they risk repetition. They also obviously take time to prepare. And if time is limited, that time in preparing the written openings may then eat into your own time in preparing all openings, or even more important, cross-examination. So I think a balance has to be struck, Niamh.
Does anyone else on the panel have anything to add on this particular topic, and your Anneliese?
Yes, if I could just add a couple of thoughts. I think just adding one thing to Andy's comments on knowing your tribunal, remember that advocacy is actually the art of persuasion, and you're persuading real people. So it's always important to try and appeal to your tribunal, and you're likely to have very often to have 3 of them to appeal to. So it's different often to when you're appearing in court. In terms of written submissions, certainly as someone who sits as an arbitrator, I'd sometimes get frustrated that people feel the need in arbitration to write sort of 500 pages of submissions. Whereas in court, often you will find the court sets limits on what you can actually provide. So more is not necessarily better because someone still has to read it. And I so therefore would very much agree with Nik that having summaries of things is helpful. Obviously, in certain cases, you have to have the detail as well with proper references. So make sure the referencing is also easy for the tribunal to understand. Someone once said to me that it takes someone, you have to say something 3 times before someone takes it in. And it's quite a good way to structure written documents. I think also in arbitration, written advocacy is probably more important than in court. So in lots of these different legal traditions, obviously in the common law tradition, we place a lot of emphasis on oral advocacy. It's the cornerstone really of our system. But in a common law system, most things will be done in writing. So I do think it's important to remember that the importance that written submissions do have. A couple of things have been mentioned today, just for those who might not be quite as familiar with arbitration. Memorials are where you put in witness statements and expert reports with your case document, so your traditional pleading, just in case anyone doesn't understand that. And you can have arbitrations where you have pleadings and then witness statements and then expert reports, so you can have memorials. Memorials are particularly useful where you've got a technical case. So often that means the experts have to consider the same issues because they're one after the other. And then chess clock, just in case anyone's not heard that term before, that means that you run out of time. So tribunals will frequently divide the time 50-50 between the parties. And if you run over your time, you run out of time and you will be stopped from saying anything else. And that, again, that can be different to court, I think, where the judge might be a bit more willing to sit an extra day or allow you a bit more time. So do be aware of that. It's one of the big differences, I think, between arbitration and court. And I have seen somebody cross-examine witness 1 for so long that they run out of time. You need to plan your time more carefully.
Yeah, I mean, I was going to add just on the topic of written openings. I largely agree with what's been said, that there's always the risk of adding unnecessarily to the paper, and I think unless a tribunal specifically says that they want to be able to put aside the statements of case that have been submitted before, I would always try and treat the written opening as a roadmap rather than a restatement of the whole case, and a helpful summary of where they can find more detail and the main messages and the key references for it. I mean, I think one other sort of element to bear in mind here, which also feeds into something that Anneliese said about the different civil and common law traditions, I think, and the way in which memorials are drafted versus traditional common law pleadings, is that most sets of arbitration rules for most institutions will have a provision in them which refers to a statement of claim and a statement of defence, which will refer to advancing or setting out legal grounds or arguments as part of those statements of claim and statements of defence. So you are expected to say something about the law right from the start, which traditional court pleadings in common law countries would not have. And so that's one reason why I think the written submissions just before the hearing are slightly different in function from those that you would have in a common law court system, because you're not having to explain the law for the first time. And one of the reasons for that actually maybe goes back to something I said before, that you may have lawyers and arbitrators who are not all educated in that particular legal system. So it's right to have to set out some of the law right from the outset.
And that makes a lot of sense. I mean, I guess just moving things on so that we keep within our own time here, that brings us quite nicely to oral opening submissions. And I was wondering, do any of you have any practical advice to offer on this particular topic? Maybe Andy?
Yeah, I mean, again, a point going back to knowing your tribunal is that one issue in terms of style, I think, which is worth bearing in mind, which comes down to the type of arbitrators you've got. I mean, as a general rule, I would favour understatement rather than overplaying your case. I think it generally goes down better. But also with overplaying your case, there's always a risk, particularly in openings, that the evidence may not ultimately support it. It's better to underpromise and overdeliver. So I think that's the sort of rule of thumb. But I think as English lawyers, we are taught to understate things to some extent, and one sometimes has to bear in mind that you're appearing in front of arbitrators where there's a slightly different style of advocacy, and where unless you've thrown in some adverbs and a little bit more passion, you may come across as a little bit underwhelming. And so I think that's something to bear in mind. So you have to sometimes adapt your style a little bit without going totally over the top. But I think adapt your style a little bit to who you're appearing in front of. And if you come from a tradition where it is a more flamboyant or however you want to describe its style, you may need to temper that a little bit if you're appearing in front of arbitrators who are from a different sort of legal tradition. So I think that's one thing to bear in mind with who your tribunal are.
I guess going back to the point about knowing your tribunal and people coming from different backgrounds, obviously there's a much greater emphasis maybe on simplification than you would have necessarily in domestic court proceedings. Nik, would you agree with that?
Absolutely. I think that's one of the three touchstones for good advocacy, in fact: simplicity, preparation, and get into the mind of the tribunal, which is the point that Anneliese made. Simplicity, we all know the phrase, if only I had more time, my document would have been shorter. Just as important as shortening any written opening submissions, it's important to take time to simplify your oral submissions. The more you simplify, the more obvious and logical your cases become. I would suggest work and rework the way you put the case to see whether it can be made even more succinct. I'm a great believer in that Occam's razor, the principle that the simplest solution is probably the right one. But to simplify the case in this way takes time, and there's really no shortcut to preparation, which is, I think, the second principle for good advocacy. The touchstone that I use, and I know many other people use so far as preparation is concerned, is to try to aim to know more about the case than anybody else in the hearing room, more than the other side, more than your witnesses, more than the other side's expert, certainly more than the tribunal, and more than your opposition. Take time to analyse and understand the case factually and legally. Know the papers backwards, know the law backwards. But in preparation, be prepared to depart from what you've prepared, particularly if working under time constraints, as you almost always will be in arbitration. And I like to mark up my notes for oral submissions with points at which I depart, jump off, or abandon if time's against me. And the third aspect, as I mentioned, is get into the mind of the tribunal. Try to anticipate all questions from the tribunal. And one way of doing that as a practical matter is to read all of the written materials that is before the tribunal as if you're reading them for the first time. Try to see what the tribunal will regard as your best case, and also what the tribunal will regard as your worst case or most difficult points.
I just actually picking up on that last point that you made, Nik, we've had a question from a member of the audience. Should counsel prepare their oral arguments, keeping in mind that the arbitrator is very thorough with the case, or assuming the arbitrator is thoroughly prepared? Or should oral arguments be prepared from the perspective that your arbitrator might actually have to be led through the documents from scratch? And how do you manage those two potentialities? I don't know who on the panel might want to pick that up.
Yeah, I mean, I think this is about knowing your tribunal. You may be able to get some intelligence from others in the legal world. And again, it's important to be able to share information about how much arbitrators read. And I'm afraid some will read more than others. So you probably want to go somewhere in the middle. But I think flexibility is key. I think the real difference between good advocates and brilliant advocates are those who can answer the questions. So as an arbitrator, I often see people just reading things out, but the minute you ask them a question, they get very flustered, they can't chop and change. And I think the reason for that is actually, if you know the case, you will be able to jump around. Somebody once said 90% of good advocacy is preparation. And I think, going to Nik's point, I will always try and do a sort of case theory document that's a couple of pages, your 5 best points, your 5 worst points, your pieces of key evidence. And I think that can really help anchor you if you're facing questions. You really need to think about the bad bits of your case. We're all advocates telling our own narrative, and it's easy to ignore the bad bits, but really have thought about the difficult questions that you might be asked. And I do think when you've got 3 tribunal members, it's very rare that they'll sit through 3 hours of opening. Please don't just read things out. That's also no help at all. Try and communicate with the tribunal. Make sure they're awake. Someone once told me if the tribunal falls asleep, you just stop talking, because then they have to wake up. And another story I heard that's quite amusing is Lord Newberger, who now sits as an arbitrator, used to be the head of our Supreme Court. If counsel's boring him, he actually breaks a pencil. So if he ever does that when you're doing advocacy, but try and watch the tribunal to see if they're actually following what you're saying, falling asleep, not listening, because it's important to be able to get them to listen.
Mm.
And
another aspect of knowing your tribunal is trying to work out what the internal dynamics of the tribunal might be. So to take a particular aspect of the questioner's problem, if you know that one of your tribunal is very diligent, but one of them has a reputation for needing to be led, how do you pitch your submissions? And I think some of that may be influenced by who you think on the panel will be more decisive in relation to the particular issue you're dealing with at any one time. So for instance, you may have a tribunal member who is very diligent, who is qualified in the area of law that you are presently wanting to make a point on. So in those circumstances, I think you would be advised to be fairly short and assume knowledge of the tribunal. Sorry, Andy, I cut you off.
I was just going to add that one important source of intelligence beyond what we talked about already is the initial procedural hearing and any interim applications that you've made, particularly if you've actually had a hearing on them, because you can learn something about the internal dynamics of the tribunal from watching how they interact. And obviously this is something that is probably easier to see in an in-person hearing, I suspect, than when you're online. But nevertheless, you can get a sense of which members of the tribunal are really sort of engaging with the subject matter. But if you had a more substantive interim application, and one of them has asked lots of questions, then they've clearly started to engage with the case. And so that's a good hint as to how they might behave at the main hearing as well.
Just because just to keep us ticking along, I think probably I'd like to now talk a little bit about witness handling and cross-examination. And I've been saving this up for you, Anneliese, because I know you're a very, very experienced cross-examiner. And I was just wondering, how do you cross-examine factual witnesses effectively in arbitration? And do you have any do's and don'ts to share with us?
Yeah, I mean, I think the first thing to say is, however experienced you are, cross-examination is an art. And a very good friend of mine, Rupert Jackson, who is now an arbitrator, he was a Court of Appeal judge in England. He told me when I was training that he used to, after every case, write down 3 things he'd done well and 3 things that he hadn't done so well, so that he could improve. So I think the first thing is, if you find it hard, don't give up. It is a difficult thing to do. I think cross-examination is not examining crossly. That's point 1. I think in most of the cases we do as well, you are likely to have the most effective cross-examination from documents. So it's not sort of like TV, he said, you said, I put it to you. People are not going to agree, but you can show someone is not telling the truth or can't remember things through documents very, very effectively. I do think you need to be careful in arbitration that most arbitrators don't like really, really aggressive cross-examination, probably less so than judges, and it's going a bit out of fashion generally. But I think you can really put it effectively through documents, knowing the documents, again, preparation, being able to listen to what's being said is incredibly important. So you can have a script of questions, but if someone gives an answer, you have to react to it, and you might have to change tack. So often what I do when I write notes is I have a topic heading and a list of bullet points of the points that I want to cover, and then you can jump around. So you have to be prepared to go off script. Obviously, please don't just read out what someone else has written for you. I mean, you have to prepare it yourself. You can have help, obviously, but you need to know the documents, and you can always tell when someone is reading out something that someone else has written for them. Again, you will in arbitration, I think, have more limited time for cross-examination. It's not generally the same rule as in court where you have to challenge every point. And that actually gives you some freedom, so some choice that you can actually choose your best points. You don't need to challenge everything. And if you've got a number of witnesses, next week I'm doing a hearing where I've got 12 witnesses to cross-examine in 5 days. So I have to have finished my cross-examination by the time I start, because I have to be very conscious of managing my time because of this chess clock issue. And also focus on the important points. You often find in arbitration, people write statements that cover lots of things where you don't need witness evidence. So take an issue of what a contract means. Often witnesses say what they think the contract means, but certainly if you're acting under English law, it's inadmissible, it's irrelevant what the witness thinks. So you need to pick out the points that actually you challenge as a matter of fact. You obviously do need to put allegations of dishonesty or those kinds of things if you're making them. Don't be surprised if you're against people from another jurisdiction. I find in the States they make allegations of dishonesty all the time, probably more readily than we do. That's just their tradition, so don't be too taken aback if you find that happens. And again, just be as reactive as you can. Listen to the witness. You can sometimes get really good information out of open questions depending on the witness, so it doesn't have to be all closed. But again, try and get as much experience as you can of it. It's a bit like driving a car. The more you do it, the better you will become. And, I think particularly for the younger listeners, if you're, ask for an opportunity to cross-examine a small witness. Don't be afraid if someone says, would you like to take this witness? It's the only way you will really learn. You can watch someone else till you're blue in the face, but ultimately you need to have the courage to try and take witnesses on your own and just practice and learn.
And I was going to add, I think picking up on what Anneliese was saying about the chess clock and the limited time, I mean, as well as sort of thinking about which points to put to your witness, I think that limited time also affects how you approach it. And one thing in particular that you can't do generally in an arbitration is have a long run up. There are obviously some things where you need to set it up to some extent, and you may not want the witness to know exactly where you're going. But there are other points where it's pretty obvious that you're going to ask them about it, and you may have maybe sort of simple point where you've got to put it to them. You've got a few documents you need to put to them. It may just be you go straight to the point on those and see where you get to, rather than that sort of long run up that just wastes time. And that's particularly, I think, for the secondary points of importance, or ones which, as I say, are obvious and are not going to be you're not really giving up very much by way of surprise.
I just wanted to ask a question because Andrew had touched on the issue of language barriers at the very start. I was wondering, do any of you have any specific advice on how you cross-examine someone when they're giving evidence through an interpreter? Because that's always struck me as been a bit trickier.
Yeah. Shall I say something about that? I mean, I've cross-examined people through interpreters quite a few times, and I think the first thing is obviously it takes longer, and it's often something where you're negotiating actually the amount the chess clock. If you've got several witnesses on the other side, bear that in mind when you're talking about your timings. Are you going to have equal time with the other side who are all cross-examining in the language of the arbitration? Because that may give rise to some unfairness in terms of how much you can get through. But then when you get into the arbitration and you're actually cross-examining them, I think the difficulty is first of all establishing a rhythm, and secondly shutting up a witness who wants to talk at length, and you can't as easily interrupt if you've got to wait for them to finish, wait for the interpreter to explain it all. So the only way really to deal with that, I think, is to say something polite at the end of that answer, and then effectively prompt the tribunal to be aware of it and hopefully step in as well if they continue doing it.
One war story just reminded by what Andy's just said. I was cross-examining a very loquacious Italian through an interpreter who simply would not answer the simple question yes or no, and all of his answers went on for 3 or 4 minutes, and the poor interpreter was interpreting once or twice the entire answer. By the 3rd or 4th time, after the judge also swung in and said, "Mr. So-and-so, you have to answer yes or no," we got yet another 2 or 3 minute long answer, to which the interpreter turned around and said, "Yes."
Anneliese, you were going to say something as well, I think.
Yeah, I mean, I think that you have to make your questions very short, and you have to think much more, actually. You do, contrary to what I said before, I think if you're cross-examining through an interpreter, you do script much more, and you need to make the questions as simple as possible, and as, try and get yes/no answers rather than long explanations. Also be aware sometimes people can understand, they just want to they want some time to think about your cross-examination. I did have a very funny moment where the witness actually ended up answering the question. Often they answer the question, they can understand English, but they're not very confident of answering in English, so they end up answering. So you can also get to a point where sometimes, I mean, Andy and I had this in an arbitration, where questions are asked in English and then they can ask for help in giving the answers. So I think, you still need to also try and establish a rapport as much as you can with the witness you're cross-examining, but it is a different skill set. I will come on to talk about virtual arbitrations, but I think virtual arbitrations are giving us all extra skill sets in how to cross-examine through an interpreter, because lots of the skills are quite similar.
I actually wanted to pick up on that now, if you don't mind, virtual hearings, because we've had a question from an audience member about, how your approach differs in terms of virtual hearings. So maybe we could usefully deal with that now.
Yeah, I mean, it's again, you have to be more scripted, more precise, shorter questions. You can't interrupt. It's very, very seen as bad form. The tribunal will get very upset if you interrupt, particularly on a virtual basis. So you need to, I think, prepare much more as you prepare to cross-examine through an interpreter. And you need to be very organized in terms of making sure the documents are available, the witness can see them, all of those things. You can't just hand up documents in a virtual hearing. So it's different and it's the same. Obviously, the other thing that happens is everyone can see everyone's faces. So that's one thing that clients have said. They can actually see my face when I'm cross-examining, whereas often they can't, depending on how the room's set up. But also you can see the witness's face. So it's quite intense. It's it's even more tiring than cross-examining, normally. What I would say is for young advocates out there, this is a great opportunity for you to really shine. I've seen some very experienced QCs cross-examine terribly. Virtually, because they're used to being able to stand up, walk around, use their kind of body language to intimidate a witness. You can't do any of that. And I've done some training with young advocates who are absolutely brilliant. They were all over the electronic bundles. Their questions were very precise. So, just bear that in mind. I think it is a great opportunity for younger advocates.
I had one other question from an audience member that I wanted to pick up, if one of you could pick it up, which is any tips on how to maybe not break, but tackle a tutored witness in cross-examination. So someone who's obviously been coached to within an inch of their life.
I mean, I think you have your plan as what you want to get out of them, and you follow that. And the fact that they're tutored often becomes clear, and so I mean, I think what happens is that if they have a stock answer that they're going to wheel out, let them wheel it out, but then don't get distracted from what you really wanted to ask them and go back to it. And if they keep wheeling out stock answers, then it just becomes very obvious to the tribunal what they're doing, and that damages their credibility. So I think I wouldn't get too worried about somebody who's been over tutored. I think it just ultimately can be self-defeating, to be honest.
Completely agree. You can tell a mile away when someone has been familiarized or coached. Does anyone else? Sorry, Anneliese?
No, but don't get frustrated, because of course, that's what you sometimes see, that the advocates become so embroiled personally in it. You always want to remain calm, even if inside you're seething. I have a funny story when I was very young cross-examining someone, and they said, "Why are you raising your eyebrows at me?" I actually had no idea I was doing it, but obviously the story that he was telling me was so incredulous. But yes, I have seen advocates become very emotionally involved. It's always better to, just try and remain calm, even if somebody is having a go at you, which can often happen.
And I think there's probably the tactical, deciding whether or not to leave someone in the box overnight, for example, takes on a different significance if you think they're about to be home and sent back to class to learn more lines to spout out the following day as well, as another consideration. Does anyone else have anything further? Oh, sorry, Andy.
No, I was going to say I think that's probably right. Although if they have been tutored to that level, you may also wonder whether how it's going to play out. You may expect that there's going to be further tutoring, regardless of what warning they get from the arbitrators. The only other thing I was going to say was about virtual hearings, and Anneliese was mentioning a client telling you that spotted the eyebrows going up. I mean, that's something that actually, depending on how you set up your screen in a virtual hearing, you can watch yourself. And you may want to think quite carefully whether you want to do that. I mean, I must admit, when I've done it, I have had my own picture up along with everybody else. And I personally don't find it off-putting, but I know some people say they do find it quite off-putting. So that's maybe something to experiment with. But the other thing is, which may be an advantage, which maybe makes up for some of the disadvantages of the virtual hearing, is the fact that it can, if you have your Zoom call on gallery view, you can also look at the arbitrators and the witness at the same time much more easily. You don't have to turn round to look at the arbitrators in the way that you often would in a horseshoe shape. So that can be something which can help you to see how the evidence is going down as you go along, because it is important to not lose your focus on the witness, but also to see how the arbitrators are reacting.
But also, as an arbitrator, it's frustrating in a virtual hearing because you can't see everybody in the room, and you realise how much you rely on, when a witness is giving evidence, just watching what people are doing. So again, if you're watching someone being cross-examined in real life, please don't give everything away by your face. And as I say, it's one of the things, I think, if you're a judge or an arbitrator, it's a bit frustrating that you don't have all those clues. So yeah.
And I guess as an advocate, you don't get that, to use your own body language in the same way when the witness gives a very incredible evidence, kind of turn around to the arbitrator's like, did you do that? But
yeah, but you can use language on a virtual hearing. So what I've noticed is people actually, quick fire questions again and again can have the same effect as perhaps intimidating a witness with body language. So I've seen witnesses completely collapse and they just end up making loads of concessions. I think because it's just like question, 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 which isn't how you would really cross-examine in real life, but it can be quite effective on the screen. So I think practice, you need to practice before you do it. It is a different skill set in many ways.
And also bear in mind the stories we've heard come back from witnesses who say themselves that they find it far more arduous being cross-examined virtually than in a live setting. So you can use that to your advantage.
Absolutely. I wanted to touch briefly on experts because we're slightly running, we're dealing with questions as they come in. Anneliese, what are the most experienced techniques, most effective techniques in your experience in tackling cross-examining another side's expert?
I mean, again, I'm going to sound like a broken record, but it's preparation. It's spending time with your own expert and trying to understand the technicalities of what the expert's going to say. And unlike a factual witness where you'll be able to react quite quickly, particularly if you know the documents, with experts, they're obviously experts in their field. You are never going to be as expert as them. So you need to talk through with your own expert. So if the expert says this, what am I going to say? So the answer to every question, your expert should hopefully know roughly what their viewpoint's going to be or what they might say on a particular topic. But expert witnesses take a lot of time to prepare and don't think you know it. Use your own expert. Have a look online. It's amazing what you can find online. We found an expert had written some PowerPoint presentations which were completely the opposite of the opinion he was presenting. Andy and I did a case where we found out that the expert hadn't disclosed that another bit of their company was doing lots of work for the client, so they weren't independent at all. So those sorts of things, credibility, showing things that they're not independent, arguing the case for the client, those sorts of things. You want to make the tribunal trust your expert and distrust the other side's expert. Again, look for flaws in logic, but I think you have to think very carefully before trying to take on an expert on their expertise directly. And if you're going to do that, you have to be super well prepared and know how technically you take them down. Having said that, if you take an expert down, there's nothing more satisfying. And it so often happens that I think people write reports thinking they'll never be cross-examined on them. So you can have a lot of fun, I think, with experts. I think the tribunal will allow you more room actually to be quite aggressive is the wrong word, but assertive with them, because they're professional witnesses. They chose to come and give evidence. Whereas I think with factual witnesses, the tribunal naturally feels a bit sorry for anyone who has to come and give evidence and will be much more protective of factual witnesses because they're just there giving their evidence. But I think for professional witnesses who haven't done their job properly, you really can go for it in the right circumstances.
I think one other thing I was going to add to that is always look carefully at the other experts' instructions. What have they actually decided or given an opinion on in their report, and what have they been asked to assume? And often that can be a way of dealing with it, to point out that actually there isn't really any evidence on this. It's just an assumption, or an assumption that we're given on X necessarily means they have to take position Y. Those sorts of things can be really useful in terms of undermining the evidence and effectively removing the point from the realm of the expert evidence into something else where you may be able to argue about it later. You may not even need to cross-examine anyone about it. You may just be a point of argument later.
And depending on the area of expertise, I do a lot of work in financial matters, and often there's a lot of quantitative work that goes on in the background that informs an ultimate expert report. Any expert report drafted in that way should disclose precisely who's done all that background quantitative work, but sometimes it doesn't, or even if it does, sometimes the expert who's standing up and giving evidence maybe doesn't fully understand the quantitative work him or herself. So there's all sorts of opportunities presented there. And just if the case is big enough, the other point, picking up Anneliese's point about relying on your own expert to give you a hand, in a case where there might be various types of quantitative expertise required, even if you're not putting forward expert evidence in that particular field yourself, if the case would bear it, it's worthwhile considering whether you should get a background expert to help you understand the particular area.
I just wanted, just because we're again trying to keep us up to time, the one other question I wanted to ask about expert evidence relates to hot tubbing, which is, you know, when you have all your experts giving evidence simultaneously, and it's much more of a dialogue. And I was wondering, do you find it helpful? Are there times when you'd avoid it? What would your advice be to our audience members? I mean,
well, I've dealt with hot tubs quite a few times, and they can work very well, but they can also work pretty badly. And I think it largely depends on the degree of buy-in you get from everybody that's participating, and in particular the tribunal, because often I think it works best where the tribunal leads the process, and particularly with the questioning. But I mean, as with so many of these things, preparation is key. I think there are different ways in which you can manage a hot tub. And so it's important that you lay out the ground rules and agree what the approach is going to be in advance, well in advance of the hearing. So not just on the day itself, you want to be figuring that out well in advance. And the other thing that I think really helps is if the experts have had a meeting or conferring in some way in order to clear up or clarify what are the issues that are in dispute and what are the issues where they agree, and that can provide a roadmap. And then the most effective way I've seen it done is where the tribunal then takes the lead on the questioning, goes through topic by topic and asks questions. But at the end of each topic, counsel get an opportunity to ask follow-up questions, and that I think is a good mixture of giving counsel the opportunity to go into the points that they think are important, but also having the tribunal be able to focus on what they don't yet understand, or what they understand, what they think is going to be important for the case. And it can also then sometimes be useful to have a bit of time right at the end, after you've dealt with all of the topics, for counsel to ask sort of general follow-up sweeper questions if they need to. But as I say, I think it's important to have it in advance, but it's also important to be ready for anything, because you may agree it, the tribunal may not quite follow it, and so you do also need to be prepared for it to go a little bit off script as well.
Yeah, I mean, a couple of additional thoughts. I think just in case anyone doesn't know, hot tubbing, or it's more frequently now actually called concurrent evidence. I think hot tubbing is a bit of a strange word, but it means the experts sit next to each other and give evidence at the same time. Now, if you have a case, you also have to think whether your case is going to be suited to that. It's much more likely that the experts will agree with each other when they're sat next to each other. I don't know what it is, it's a human factor. I very much agree with Andy that I think sometimes as advocates, we think, brilliant, now I don't have to do a whole 3 days of cross-examination of experts at the end, and this will be an easier way of doing it. I actually think it's more difficult to do because it involves planning and sort of surreptitiously getting your experts' points in. I think you need to, as an advocate, have a hand in shaping an agenda. So normally if I've got concurrent evidence being given, we would have a list of topics that were being covered, and we try and help the tribunal navigate their way around that. And I think also be aware of whether your own expert's done it before, how likely they are to be able to cope with it, because it can. But I absolutely agree with Andy. When it works best is when the tribunal asks questions, because then actually you get a lot more agreement between the experts and you really get to find out what the issues are. The other problem with it is, though, if you have experts who are very dependent on assumptions or where credibility is a real issue, you can't really deal with that within the context of concurrent evidence. So you may need to ask for, I've sometimes had half an hour just on credibility or the basis for the expert's report. So a sort of mix and match approach.
Yeah.
You have to bear in mind when faced with the prospect of hot tubbing that as a result of loss of control over the questioning, you have a certain lack of control over the way your case is being presented. So again, it comes down to preparation and the ability of you to really hone some pointed questions in the times that you have to answer them to try to present the case in the way that you want it to see.
Yeah. I mean, I think the other two things that you can also bear in mind is, one is it useful for the experts to make a short presentation at the start? And that can be useful, particularly if it's really quite technical and there's something that they need to explain. But you, again, need to work out what the ground rules for that are. Is it intended to be an overview of everything they've done, or is it going to focus on specific issues? And I think you want to have a time limit as well. And you also need to be clear as to whether, to what extent new information can be added at this stage, because I have seen it happen where you effectively get, through the medium of a PowerPoint presentation, a whole load of new analysis that you've never seen before. So you've got to be a bit careful about that. But the other thing I think is, when you are asking questions to the other side's expert when they're in a hot tub, they do just keep looking at your own expert and give them an opportunity to say something, because the whole point of having the two witnesses giving evidence together is to allow them to react to what the other one's got to say. And Anneliese said, I mean, it's more when you're cross-examining an expert, it can be quite difficult to react if they come up with a technical point. But if you've got them both there, then your own expert may well be able to react to that and contradict the point, and it may be something you wouldn't have even thought of.
And I thank you all very much. I'm going to draw a line under the kind of panel discussion in the interest of turning to some more of the questions that I've not been able to work into the more general questions I've not been able to work in. So we've had one question asking for tips for acting as arbitrator when you were younger. So more junior people taking on roles as arbitrators early on in their careers.
Yeah, I mean, obviously you can be a tribunal secretary. That's a very good way to get into it. I think it's also just trying to talk to people. Don't be afraid to tell people that's what you're interested in doing. Again, I've seen with the pandemic, a lot of smaller cases being dealt with virtually. So talk to people at the institutions. You know, they often look for younger arbitrators to deal with smaller value cases. I think just try and network as much as you can, and don't be afraid to ask for help and let people know that's what you're interested in doing, and try and shadow other people to the extent you can.
Yeah, I mean, the other thing that can be helpful, particularly in Asia, is becoming a fellow of one of the institutes. There's the Chartered Institute, and then there's a range of institutes in different countries around Asia, and often becoming a fellow is seen as a kite mark for the institutions to get on, not necessarily their primary panel if you're a new arbitrator, but at least they'll onto a reserve panel for their smaller value cases. So that can be a way in to get some initial experience.
And we have a kind of similar question as well. Top skills that you would look for in a junior arbitration counsel when you are leading counsel. Do you have any insight on that?
Well, I mean, I think you're looking for sort of diligence and enthusiasm amongst other things. But I mean, it's many of the general skills of a lawyer. I think that you want, if you've got somebody that's assisting you and helping you put things together, and then a degree of confidence if you want them to take on a speaking role as well. Anneliese may have some thoughts on that.
No, being able to answer questions, you need to be able. I think that is such a thing that distinguishes good advocates from brilliant advocates. So, you know, practice debating with someone else what you're going to say. Get them to ask you questions, and you know, practice responding. People who can engage with that. I think a lot of young advocates actually know the documents better than more senior advocates. So don't, you know, I think a lot of you will have done huge amounts of preparation. I think a lot of it is just practice and confidence. So, you know, take whatever opportunities you can to practice. I do also think you need to know what are your good points and what are your bad points, and take the good points. Like, don't be afraid to make concessions on bad points. You'll retain your credibility with the tribunal. So be able to distinguish between that. And again, in cross-examination, you know, what are the really important points, the important documents? I often have to listen to a lot of, you know, questions on tiny inconsistencies in witness statements. And, you know, I just don't think that's going to get you so far as showing me a document that shows that witness has just got it completely wrong. So again, that's the kind of thing you learn through practice. So take whatever opportunity you can to practice, you know, positively ask to have a witness in a hearing. If it's terrifying to you the first time you do it. I mean, next week I've got 12 witnesses. I still get nervous. No one will see that. You know, you need that adrenaline. And then when you start, it's all fine. But, you know, don't worry about that. And the more you do it, it's also incredibly enjoyable thing to do.
I always think, just speaking as a junior, kind of who's always the junior and never leading counsel, it's the same approach that you would take to a tribunal. You know, you establish your credentials and your credibility by being reliable and credible, but also by helping the tribunal. You know, the more helpful you are, the more they will rely on you. And the same goes with your leader. Use that as an opportunity to show that you can present things in a way that makes their life easier rather than harder. And, you know, it's of equal application in that context. So just turning to some last couple of questions, because we have a little bit of time. What is the best way, we slightly dealt with this already, along with a lot of the other ones, but what is the best way to re-engage the tribunal if you find them losing interest, apart from the examples that Anneliese has given of pausing? Do you have any other tips, or have we covered that?
Perhaps,
I mean,
sorry, no, I was going to say briefly, perhaps change topic. Reserve what you had been saying that was boring them for further submissions or further examination later on, and move on to something that you hope will engage them or that they've indicated an interest in, and then try to work it back to the more boring stuff.
I think also there's a difference between where the tribunal might be being hostile to you and then just completely disinterested. Completely agree. If they're disinterested, change topic. If they're hostile, this is where judgment's really important. Sometimes you have to persist and, you know, but try and think of a different angle or a different way to put it. So yeah, I think it depends slightly on what the mood music is you're getting. But people being bored, you have to then move on. You have to be flexible and think about coming at it a different way.
And I think also it's a pretty good indication, like if the judge isn't interested in it, you know, or the arbitrator, either they don't think it's a very contentious issue, or, you know, they've already, you know, seen enough of the documents to be more or less satisfied about a particular point. It's always much more nerve-wracking when they sit up and start taking notes furiously. So I'm just having a look at the final questions. Where you have a chess clock or some tight time estimates, and the other, you fit within your timetable, but the other side sometimes take more than they might have been allowed, and you think that's unfair. Is there anything that you can do to redress the balance, or do you just have to take the lumps and, you know, acknowledge that the tribunal thinks it's important that the other side get additional time to deal with certain points?
I mean, it depends. Most tribunals will actually stick quite rigidly to it. And normally there's someone who's keeping a note of how long. Equally, I mean, again, this is an arbitration Andy and I did because we had some witnesses who were giving evidence through an interpreter. The tribunal allowed us a bit more time just because it took longer. And I think you have to know if that's the case, you're just going to annoy the tribunal if you make a massive fuss about it. If it's outrageous and they're being allowed time for no good reason, then you have to be perhaps a bit more strenuous in, you know, protecting the position. But again, it's an issue of judgment depending on why there's not an absolute strict chess clock. But most tribunals will be pretty strict because in order for their awards to be enforced, there has to be a good reason for chess clock not applying.
This talk on timing brings us quite nicely to the fact that it's just gone 31 minutes past 11. That's all we have time for. So that just leaves it for me to thank my other panel members, Anneliese Day QC, Andrew Pullen and Nik Yeo. Thank you so much for joining me today and for sharing your insight and experience with myself and all of the audience. And we're already getting comments saying thank you very much. So I think it's been very much appreciated by the audience members. So thank you. Thank you,
Niamh. Very well said.
Thanks, Niamh.
Thank you so much, everyone. A big thank you to all our panelists for this extremely insightful session. We did touch upon a few, important topics, including witness submissions and pre-hearing submissions, their pros and cons, importance of simplicity in submissions and the case to be effective, cross-examination and effective ways of preparing well yourself, prepare well with your own expert, as you said, aspects of hot tubbing and so on. And just on a lighter note, not letting your tribunal fall asleep, right? So thank you so much on this. And to our audience, please re-log in for our next session at 6 p.m. IST, which is on resolving disputes in construction industry, Africa and India perspective, hosted by and presented by Link Legal and Lasiak. See you then. Bye, everyone.